Every US visa story begins with one of three ingredients: love, talent, or money. Today, we're talking about love. One of the biggest immigration stories this year wasn't about a visa, it was about babies. Specifically, whether children born in the United States continue to receive US citizenship at birth. The issue reached the United States Supreme Court, and the decision has enormous consequences for families around the world. I'm Tapias, CEO and immigration attorney at Loigica. And today, I'll explain what the court decided, who qualifies for birthright citizenship today, what birth tourism really means, and some of the biggest misconceptions I hear. What did the Supreme Court decide? In late June, the United States Supreme Court held that children born in the United States to parents who are unlawfully present or only temporarily present are citizens at birth under the citizenship clause of the 14th Amendment. In other words, the court rejected the effort to limit birthright citizenship through executive action. The court concluded that children born in the United States who are subject to the jurisdiction of the United States remain U.S. citizens at birth under the Constitution. So today, birthright citizenship remains the law. Why does this rule exist? This principle goes back to the 14th Amendment, adopted after the Civil War. The idea was simple. If you are born in the United States and subject to its jurisdiction, you are an American citizen from birth. It creates certainty. It avoids children being born without a nationality. And for more than a century, that principle has been part of American constitutional law. Who qualifies? So who receives birthright citizenship today? In general, almost every child born on U.S. soil. That includes children born to U.S. citizens, lawful permanent residents, temporary visitors such as tourists, students, or workers, even parents who may not have lawful immigration status. There are a few important exceptions. The most well-known involves children born to accredited foreign diplomats, such as ambassadors and certain diplomatic officers, because diplomats are not considered fully subject to U.S. jurisdiction in the constitutional sense. Their children generally do not acquire U.S. citizenship simply by being born here. What about birth tourism? This is another area that creates confusion. People often ask me, is birth tourism illegal? The answer requires a little nuance. Giving birth in the United States is not by itself illegal, but using a visitor visa while concealing that your primary purpose is to come to the United States to give birth can create serious immigration problems. Visa applicants are expected to be truthful about the purpose of their travel. And if a consular officer concludes that someone obtained a visa or entered the United States through fraud or material representation, that can have serious immigration consequences far beyond the birth itself. So this is really a discussion about honesty during the visa process, not about the citizenship of the child. The biggest takeaway is this. As of today, the Supreme Court has reaffirmed that birthright citizenship remains protected under the 14th Amendment. That does not mean the political debate is over, but it does mean constitutional rule remains in place today. If your family has questions about citizenship, immigration options, or how these recent developments may affect your case, our team at Loigica would be happy to help. And remember, every US visa story begins with one of three ingredients: love, talent, or money. I'm Tapias. I'll see you in the next video.